Welcome back, everybody, to the Law of Tort. We finished the previous lesson talking about the old law on the question of psychiatric injury and psychiatric harm, talking about the concept of there at least originally being no potential ability for an individual to actually make a claim on the basis of pure psychiatric injury. Now, in this lesson, what I'm going to do is talk about the development of the case law on this issue, talk about how we see future cases start to build on those that had previously been established in being able to come up with some kind of conclusion in relation to the development of psychiatric injury as a substantial principle of law. As I mentioned, we finished by looking at the old law on the idea of there being a failure in a claim of psychiatric injury in the case of Victoria Railway Commissioners and Coltas. Remember, that was the case where an individual had negligently in their duty of care, breached said duty of care in essentially leaving a gate open, which allowed people to drive over a railway track. They were very, very nearly hit by an oncoming train as a result of this negligent action, and they were traumatized as a result of the event that had taken place. Now, they argued that as a result of this traumatic experience, the trauma itself can represent damage by way of pure psychiatric harm, and so therefore they could make a claim in negligence as a result. But of course, the courts said, no, you can't make a claim in negligence on the basis of pure psychiatric harm. There has to be an attached physical injury to that particular element as well. This lesson is going to talk about a number of cases which has seized the essential expansion on the concept of psychiatric harm being a claimable issue within the law of torts, specifically within the tort of negligence. We're going to begin with a case that takes place a few years after the Railway Commissioners case with Delio and White from 1901. In this case, you have a pregnant barmaid who had suffered shock, and as a result of this shock, they therefore had a miscarriage. Now, the shock was caused by a defendant who had negligently been driving a carriage which had then crashed into the pub where she had been working. So, to set the scene, you have a pregnant barmaid. She's working behind the bar at a pub, and a person, a driver of a carriage, was negligently driving and crashes into the front of the pub, which causes the barmaid to have quite significant shock as a result of the event. That shock then subsequently leads to a miscarriage. It was held that the concept of psychiatric injury being limited purely on the basis of potential fraudulent claims was actually an unwise position that the law could take. Such a course involves the denial of redress in meritorious cases, in cases which have merit, and it necessarily implies a certain degree of distrust, which I do not share, in the capacity of legal tribunals to get the truth in this class of claim. So essentially, this case illustrates that the courts were quite hesitant and relatively disagreeable when it came to limiting psychiatric injury and to limiting potential claims for psychiatric injury on just the basis of fraudulence. So to suggest that we're going to limit psychiatric injury claims, okay, well, we're going to do it only because they could be potentially fraudulent. That is seen to be something of a limitation in the law. And it also seems to be the case that the courts are not trusting themselves to be able to identify meritorious cases and to be able to distinguish between them and fraudulent ones. In 1925, we see another case that relates to the concept of psychiatric harm. This was another case involving a pregnant woman. This time, this pregnant woman had witnessed, should I say, a lorry roll down a hill without a driver. The lorry sort of rolled down the hill and then sort of round a corner beyond her field of view. So when it went out around the bend and out of sight, it then crashed to an area where she had just dropped her children off at school. So one of the things that should be noted is that she did not see the crash. She didn't even know at the time that it was her children that could have been injured as a result. Her shock from the possibility that the lorry may have injured or killed her children caused her to have a miscarriage. In reality, only one child suffered some injury as a result of this event, but the idea that they could have all been injured or that they could have been killed as a result of witnessing the lorry rolling down a hill causes her to have a miscarriage from the shock and the psychiatric harm that was caused. The claim in psychiatric injury would actually succeed on this basis, and it would be consistent with the precedent that was set in the case of Deliu, because that was also a case where you see psychiatric harm be established and the case also succeed. They were both similar cases. In 1943, then, we get another case, the case of Borhill and Young. This case represents something of a contraction of the principles that we see in the previous cases. So the case law on psychiatric injury seems to expand and expand and expand, and then the case of Borhill and Young sort of reins it back a little bit and restricts some of the abilities to make claims. Again, it involves a pregnant woman. This pregnant woman was getting off a tram. At the same time, but on the other side of the tram, outside of the field of view of the woman, and actually quite far away, a motorcyclist would actually hit a car, and the rider of the motorcyclist would be killed as a result. Now, the woman did not see the collision. She was in no way in any kind of danger herself to actually have been to have collided with anybody. All she had seen was the resulting blood, which was on the ground, on the pavement, as a result of the collision. This is what caused her to go into shock, resulting in the stillbirth of her child. Now, the question here is, could she claim on the basis of psychiatric harm, owing to the fact that the driver or the motorcyclist had been negligent in their action and so was caused the accident? In her position as a mere bystander, it was held that she could not claim in negligence. She was in no danger herself, damage to her had not been reasonably foreseeable, and there was no view that she could have essentially made a claim by way of some kind of secondary victim, by witnessing a traumatic event which involved somebody of someone with close ties of love and affection, unlike the previous case of Hambrook and Stokes. Finally, then, let's look at the case of McLaughlin and O'Brien from 1983. In this case, you have a claimant who was a mother, and she had learned via a phone call of her family being in a car accident, the rest of her family, which involved a husband and some children. When she arrived at the hospital, she's seen the injuries which were incurred onto her family members, as well as the news that one of her children had died as a result of the accident. So a particularly traumatic event. She would then suffer from depression as a result. This is the recognized psychiatric condition that is necessary as a prerequisite for making claims in psychiatric harm. Now, it was held that her claim would be successful, as she would be something known as a secondary victim for the purposes of psychiatric injury. Now, we're going to get into the distinction between primary and secondary victimhood as time goes on, but one of the things that should be noted at the moment, just as a basic overview, is that there was the relevant time, there was a relative proximity to the traumatic event, as well as a perception of the aftermath of the event. There was also a relatively close connection to the people who were victims in this event, i.e. these were family members. And so all of these contribute to this idea that a secondary victim could be established on the basis of psychiatric harm.